Yeah.
I don't even recognize you over here. I don't even recognize you. Okay.
So far, I think we're good.
I was getting a low bandwidth message for a minute there, Judge. So if it freezes up, just let me know and I'll go back.
Okay, I'll do this. What we should do is have like a hand signal if there's a little bit of a freeze. I'll just kind of, yeah, we'll go like that, and then freeze.
Yeah.
And it's easier too, just so if when the witness is testifying, I might keep it on. If you keep it on speaker view, then that shows who's speaking is the biggest. So we are. Let me make sure. Stop. Cancel. Okay. We are recording right now, and we're on the record, the Zoom record, in the matter of the state of Georgia versus Gregory Wampler. It's 20W04588. The case right now is called for a preliminary hearing. Mr. Wampler is appearing via Zoom video conference with his attorney, Mr. Lewis. Mr. George represents the state, and we have Officer Bentley, who is also present via Zoom. Mr. Wampler, the matter is set down for a preliminary hearing, which means the only thing for us to do today is to determine whether there's enough evidence on a probable cause standard to allow the warrant that I've indicated. And that warrant is for, let's see, we have, is it just an added charge? We have 2 warrants. I'm sorry, we do. I'm just looking at it. It's 20W04588, and that is for possession of methamphetamine, and 20W04589 for possession of cocaine. Now, for purposes of the record, I'll state that I'm sitting in courtroom 1, which is an open courtroom, but we are conducting this proceeding pursuant to the orders of judicial emergency that have been entered in light of the coronavirus pandemic. I am recording this proceeding via Cloud Link, which I will share with both the state and Mr. Lewis at the conclusion of the hearing. These have been set down in this way to preserve the, or to follow the rules of the judicial emergency orders in using teleconferencing. And there's also Uniform Magistrate Court Rule 15.2, which allows us to do it in this way. I am in an open courtroom, and I believe we did have a no family members or anyone that else wanted to join in via Zoom for purposes of this proceeding. However, attorneys are always welcome to share this link with whomever wants to witness the hearing for purposes of an open courtroom. They're welcome to be on Zoom, and I would just keep everybody muted. A little bit of Zoom etiquette is if I'm not going to, because we don't have that many people, I'm not going to mute either Mr. Lewis or Mr. George for purposes of any objections or things like that. But because we are on a video conference, what I'm going to ask is that if we do have someone who needs to object or something like that, you can state objection. If I can't hear you, just wave your hand. Now, the way it looks on the side is just to make sure, if you're not familiar with Zoom, I have it on speaker view. So speaker view in the top right-hand corner shows the one who is speaking is the biggest. That might be more helpful for purposes of the proceeding, that you'll be able to see the witness better as he or she is testifying. If you only see one person on the side, you can click on one of those little bars and it should drop down a view of everyone to make sure. Like I can see, and then if you can't see everybody, there's a little arrow at the bottom that you toggle down and I can see all of the attorneys. Can everybody see and hear sufficiently? Mr. Lewis?
Yes, thank you, Judge.
All right, Mr. Wampler, can you see and hear sufficiently? All right, Mr. George, same for you?
Yes, Your Honor.
All right, and Officer Bentley. Okay,
Yes,
and I will say this is actually pretty cool for me. I've been working on this for a minute. Officer Bentley is appearing via Zoom through his mobile data terminal in his patrol car, which is pretty cool. And you're safely pulled over to the side of the road, correct?
Yes, ma'am, in part.
All right, so if you saw that when Officer Bentley talked, his image showed up the biggest. So what I'm gonna do is I'm gonna ask, make sure the state is okay with proceeding via Zoom. Does the state waive any deficiencies or technicalities in this process, Mr. George?
Yes, Your Honor.
And Mr. Lewis, same question.
Yes, Judge.
All right, then what I'm gonna do is ask the state to call its first witness, and I see
Can we address 2 things first?
Of course.
Well, 3 things. One, when you speak, Judge, if you're not speaking directly at the camera,
Oh, you can't hear me as well?
Yeah.
Okay.
Okay, that's the first thing. Second thing is,
Need
if
headset.
if I want to talk to my client, I'm gonna hold up one finger so I can mute it, so I can just speak to him.
Perfect.
Otherwise, I'm just gonna have him write notes so that we can continue on with the hearing.
And if he needs paper and pen, we have some of those.
He's got that, he's got that.
Yeah.
He's
And
got
I
that.
will, oh, I'm sorry, I didn't mean to interrupt you, but, and one thing I will tell you is that because of this pandemic, we bought these laptops and they're not the greatest quality. So what I might do is get some headsets with some microphones to help make sure. But
Okay.
that's something I'm taking
I
to
got
note
you.
on.
And three, Judge, you indicated that we were gonna have a prelim. My question is, will we also be able to address bond after that?
Of course, anything in the normal course.
Okay,
Of
okay,
course,
thanks, I'm ready.
of course. Okay, and Mr. George, anything by way of technicalities or whatnot that you need to address?
No, ma'am.
Okay. All right, then I'm going to swear the witness in. Officer Bentley, raise your right hand, which you've probably never done in your patrol car before. Do you swear or affirm the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, Mr. George, your witness.
Thank you, Judge. Officer, I have two warrants. They're number 20W04588 and 20W04589, charging Gregory Wampler with possession of methamphetamine and possession of cocaine. Did you take those warrants, sir?
Yes, sir, I did.
Would you tell the judge why you took those warrants?
Good afternoon, everyone. So this incident happened on the 26th of March. It was about 8:30 at night. I was traveling down Oakbrook Parkway, which is in unincorporated Norcross, inside of Gwinnett County. I was going southbound. I observed a silver Pontiac coupe traveling northbound. It had a defective headlight. At that point, I made a U-turn and got behind the vehicle, called in a traffic stop, and pulled the vehicle over. When I approached, I met with the driver, who was Mr. Gregory. I asked him if he knew his headlight was out. He said it was his wife's vehicle. At that point, he gave me his driver's license. Returned to my car, ran his information on my MDT, and it showed he had a arrest warrant out of, I believe it was Seminole County. So at that point, I went back, pulled him out of the vehicle, told him he was being detained until I could either confirm the arrest warrant or determine it was invalid. At that point, I go to my car and I'm typing. Officer Ricks, who was on the traffic stop with me, asked Mr. Wampler for consent to search his vehicle. He granted consent. At that point, Officer Ricks pulled the front seat passenger out, who was a female by the name of Billy Stand. That's Stand. And Officer Ricks began searching the vehicle. Officer Ricks located a clear plastic tube underneath the front passenger seat, below where Miss Stand was sitting. And we found a small amount of GLM, a white crystal-like substance, and also a white chunky powdery substance inside that container. We NIC tested the substances. The white chunky substance tested positive for cocaine. The white crystal-like substance tested positive for meth, and the small amount of green leafy material tested positive for marijuana. Mirandized both Mr. Wampler and Miss Stand, questioned them about the drugs. They both denied knowledge of the drugs, and kind of pointed the finger at each other and said the other person put it there. At that point, I wasn't really able to determine whose it was, so I arrested Miss Stand and Mr. Wampler both for their narcotics and transported them to the jail. And then I obtained the 2 arrest warrants for Mr. Wampler and also the other defendant, Miss Stand.
Okay. You said there were suspected prohibited substances found under the front passenger seat. Is that right, sir?
Yes, in a clear plastic tube.
Okay. And the warrants are for cocaine and meth. You didn't take a warrant for the suspected marijuana, correct?
Correct.
Okay. So how big was this tube?
It's a small cylinder shape, probably 1.5 to 2 inches in diameter and about 5 to 6 inches long.
Okay. And approximately how much suspected cocaine and suspected methamphetamine was there? Just small amounts? Or...
Yeah, so it was, the cocaine was, I believe, 0.6 grams, and the methamphetamine was about 3.5 grams.
Okay.
And I believe the marijuana was around 3 grams as well.
And all the suspected substances were in that tube?
Correct.
Okay. Do you know how far under the passenger seat that tube was when it was found by your colleague?
I do not.
Okay. And as you said, neither of the two defendants made any statements as to ownership of those substances?
Correct.
Okay.
They both denied it and kind of indirectly pointed the finger at the other person.
Okay. Did your investigation determine who owned the car? Could you
Sorry,
say that?
repeat it? It froze up.
Oh, it
Okay.
froze up.
Did your investigation uncover who owned the vehicle?
The vehicle, according to Mr. Wampler, the vehicle belonged to his spouse.
Okay.
That's what's recorded.
And do you see Mr. Wampler, the driver of that vehicle who we've been discussing, on the video feed?
Believe so. I don't know how to make this thing bigger.
Top right-hand corner, you go to gallery view.
Okay. Yes, he's sitting in the orange jumpsuit on the video screen.
Thank you. That's all the questions I had right now, Judge. Thank you.
All right, Mr. Lewis?
Okay, Judge, I'm gonna just try to make this easier for everybody. Officer Bentley, were you familiar with my client before this date, March 27th, March 26th?
No, sir, I was not.
Okay, and if I understood your testimony, there was only one other passenger in the vehicle, and that's the female, is that right?
Yes, sir.
Did my client appear under the influence of any drugs, medicine, or alcohol when you had interactions with him?
No, sir, not that I've noticed.
Do you recall what the arrest warrant was for, the arrest warrant that you double checked?
I believe it was some type of failure to appear, but I'm not quite sure on that.
Okay, the conversation that you had with my client, was it captured on body cam?
Yes, sir, it was.
Was it your body cam, the other officer's body cam, or both?
My conversation was captured on my body camera. He had his body camera
Okay.
activated as well.
And if I understood your testimony, you went back to your car to check out something while the other officer was sort of with my client and the passenger, is that right? Let me rephrase the question. Prior to the second officer conducting the search of the vehicle, did you ever observe any furtive movements?
Okay, sorry about that. It froze up for a second. When I first stopped the car, I saw some moving around in the vehicle, but it was already dark outside. I couldn't tell who was doing what.
Okay, and I think you indicated one time it might have been the girlfriend's vehicle or might be the wife's vehicle. From your vantage point, using your police resources, were you able to figure out who the car was registered to?
I did get the registered owner's information. I don't have it handy with me right this moment.
Okay, and that's not super important. The name is not super important. Did my client at any point in time tell you that the person whose name you had as being the person registered to the vehicle, did he ever explain his relationship to that person?
We didn't specifically discuss it, but he did tell me that it was his wife's vehicle.
And I guess if the name came back on the card, let's say Susie Summerton, did he ever tell you that is in fact my girlfriend? Did he ever tell you that?
No, I didn't. Once he told me it was his wife's vehicle, I didn't question him about it further.
Okay. Okay, no further questions. Thank you, Judge.
Anything else, Mr. George?
No, Your Honor. Thank you.
All right, Officer Bentley, can we release him back to the field?
Yes,
No
Your Honor.
objection, Judge.
All right, if you want to leave the meeting, you are welcome to, Officer Bentley, or if you want to hang in till the end, you're welcome to as well. All right, I'm going to go ahead and mute Officer Bentley. All right, anything further from the state?
Just argument, Judge.
Mr. Lewis, any witnesses or evidence?
No, no witnesses, only argument, Judge.
Okay, all right. Mr. Lewis, go ahead then.
Very briefly, Judge, obviously the argument is the only thing that you have at this point is mere presence. The officer's testimony was I'm gonna summarize it. He didn't see enough of any furtive movements to say that my client put anything under the seat, nor could he say that the passenger put anything under the seat. He wasn't the one that found it. The prosecutor asked him the question about how far it was up under the seat. It's clearly not easily visible. It may be the owner of the vehicle. I don't know if it's the owner of the vehicle. I don't know if it's the passenger of the vehicle that could have put it under the seat, but obviously all the state has at this point in time is they have some drugs which have tested positive, and they have my client being the driver of a vehicle where it's not easily observed. There's no other information like the officer came out because he thought that there were drug sales. There's a defective headlight which leads to the actual stop. And I would argue that at this point it's not enough.
All right, Mr. George.
Judge, I urge the court to find that there is probable cause. It is a lower burden here compared to Mr. Lewis's argument for trial. Might be more compelling, but I do think in this case, the evidence shows from the defendant's own statement that his wife is the owner. So he is someone who has access and control of the vehicle. He's the driver. It's found under the front passenger seat, which, I don't think is determinative necessarily of who is in control over those drugs as between the two people in the car. Either one of them could have put it there. But it is a car the defendant is familiar with and was operating if it's owned by his wife, or Mr. Lewis referenced a girlfriend, but that's not in evidence. I'd urge the court to find there's probable cause based on the defendant's control of the vehicle and it's.
You're just saying it's a constructive possession case.
Driver. I think there's probable cause, Judge.
I mean, I think these cases are always, nobody's owned up to it. For purposes of probable cause, I mean, the fact that I listened closely to how he had a connection to the vehicle and he was the driver of the vehicle, it was under the passenger side, not in the back seat or anything like that. I mean, it's a constructive possession case for purposes of probable cause. I think there's sufficient evidence on that minimal standard to allow the warrants to proceed. Now, as far as bond, though, Mr. Lewis, you wanted to be heard about bond?
Yes, Judge, I'm going to request a $2,500 bond. I know that my client may have some other issues that he has to deal with. I'm going to let him talk to the court about his age, work history, things of that nature, but I'm going to be requesting a $2,500 bond. I did go over to see the prosecutor earlier before the prelim, talked about a bond. I want to say I talked about a bond with Darryl Mans. I think he ran his criminal history. Mr. George may have access to that criminal history, and we were unable to get to the point of a consent bond. It just in all candor to the court, but I am going to be requesting a $2,500 bond. Obviously, I didn't know any of the facts of the case at that point in time. I think one of the factors that the court has to consider is, he's not going to be intimidating any witnesses when the witnesses are law enforcement. Flight, flight's one of those things I always say, do I have to run away from a 98-pound weakling if the 98-pound weakling is threatening me? That's how I sort of see this constructive possession case. It's a 98-pound weakling, so he won't need to be fleeing from this. He can just go and deal with this. I suspect that this will hurt any probation that he might be on if he's on probation more than the charges themselves will hurt him. But I'm going to be requesting a $2,500 bond. I'm going to ask about 4 or 5 questions, Judge.
But wait, before he does this, Mr. Lewis, this will help me. Mr. George, what's his criminal history and what's the state's position on bond before we even get to the point of your client testifying?
Judge,
I don't mind if you wear your mask. I can hear you just fine.
Yeah, it's difficult. It goes on and off, so it's fine. It's better this way.
All right, Mr. George.
Judge, the criminal history shows a 2001 DUI and underage alcohol, a 2001 underage alcohol misdemeanor marijuana, a 2003 forgery first and meth conviction, a 2004 underage alcohol conviction, a 2006 violation of probation, a 2007 violation of probation, a 2007 cruelty third and family violence battery, a 2016 criminal trespass, misdemeanor theft, and felony theft, a 2015 misdemeanor theft by shoplifting, a 2016 failed to appear on a misdemeanor, a 2018 driving while license suspended except under no-low terms, a 2019 3-count misdemeanor obstruction and meth conviction, and a
How can that be,
2019
wait, a misdemeanor meth conviction?
misdemeanor obstruction
Okay,
and felony meth.
Yes.
Three
Okay.
counts misdemeanor obstruction and a meth conviction,
gotcha.
and then a 2019 violation of probation. All those from the GCIC I see as convictions and not just arrests. Based on that history, we would oppose bond as a risk of further felonies.
He's on probation just for the one of them still, I would assume, just for the 2019.
It would appear, I'm gonna,
Maybe the 2018 was driving while license suspended, so.
so the 3 obstruction and meth case was from Seminole County Superior Court in Georgia. And that it looks like, I can't tell if the counts are concurrent or not, at least 3 years probation, maybe 6 years probation. Depends on how they structured concurrent or consecutive.
Okay.
That's in
Okay.
Seminole County.
Okay, so the state opposes bond on the grounds, risk committing additional felonies.
Yes, Your Honor.
All right, Mr. Lewis, I just wanted to know that before you inquired of your client.
That's fine, Judge, and I'm gonna ask him a few questions. Mr. Wampler, I only got about 5 or 6 questions. Tell the judge how old you are. And if in fact.
You're gonna have to be a little closer, I couldn't hear him. Or maybe angle the computer at him a little bit. There you go.
There you go. And if in fact you are granted a bond, where will you be living?
1470 Dodge Road.
Who lives there? Is it a rehab facility?
Yes, sir.
Okay, how long have you been at that rehab facility? Is that part of the conditions of probation that you're at that rehab facility? Are you currently on probation? Where? Out of what county? How many more?
Did you say Seminole County? Seminole County?
Seminole. How many more months or years do you have left on probation in Seminole County? Okay, are you working?
How many did he, hey, Mr. Lewis, he is gonna have to be Mr. Wampler, can you be a little bit louder?
Sorry, Judge.
Okay.
Do you have a job or are you working while you're at the rehab facility? Okay, where are you working? King Steel. What type of work do you do for King Steel? Okay. How many years have you been doing that type of work? And how long have you been at the rehab facility?
6 months.
6 months. Have you had any relapses while you've been at the facility? Okay. And the owner of the vehicle, who's the owner of the vehicle? What's that? Okay. All right. Thank you very much. No further questions. The prosecutor may have some questions for you.
Do you have any, Mr. George?
As to bond, Judge, no.
I have one. Mr. Wampler, have you received any indication that you've lost your bed in the rehab facility? Because I would assume, and that's an assumption is, all I've got, is that if you were arrested, that might violate some condition or requirement, or just checking in or of the rehabilitation facility. I mean, would they have you back?
So I spoke to my wife, and my wife spoke with the director, and he said if I don't bond out, that they'd let me come back.
I don't know. I don't know if that was a condition of your probation, that you have an extended period of time in the rehabilitation facility. You weren't in the rehabilitation facility. I don't know that I'm convinced that you would have a bed back at the rehabilitation facility. And I just bound over a new methamphetamine case. I'm actually not only concerned that you're a risk to committing additional felonies, I think you're a risk to yourself.
And I guess here's the only point I would make, Judge. Obviously, you can make that one of the conditions of the bond. If you would grant him a $2,500 bond, if he was to be any place other than the rehab facility, then that would operate to revoke his bond. I don't know if the probation officer is going to put a hold on him or not. If the probation officer doesn't put a hold on him, then I suspect he should be able to go back to the rehab facility.
I mean, I don't know. I mean, the thing about it is, though, too, I think what I would be more comfortable doing is just denying bond on that ground and allowing you to file. And I can write in there that in the event you can affirmatively confirm that he's got, that he's not going to get a hold and that he's going to be taken back at the rehabilitation facility. But I don't know. I mean, in any sort of experience I've had, if he's had a new arrest, I can't imagine that the rehab facility would take him back.
Judge, I think if you're talking about him being under the influence or him trying to cop drugs or the drugs being on his person, I think you're right. I think where you end up in a vehicle where the drugs aren't on your person and there's a second person in the vehicle and the vehicle doesn't belong to you, I think that might create an extenuating circumstance. I think that the court is right. The only issue that I have with what the court is saying is, if you deny his bond today, I suspect it's going to be about 6 or 7 weeks just because of what's going on right now before I can get him back into court. And by then, his bed probably will be lost.
Yeah, I mean, I think though, the interesting thing though, Mr. Lewis, is that if I did write that in there, it's not going to be, it's going to stay as a W case. I mean, as a warrant case until for at least 90 days until it's indicted if he does stay in custody. So any bond motion would still technically be fileable in magistrate court. I don't broadcast that much, but I'm just not interested in saying, okay, I'm going to let him go back because it's Seminole County too.
Judge, I have a piece of data for you.
The rehab is here in Lawrenceville.
But it's probation out of Seminole County.
That's correct. That's correct. So that's why I say if they don't put a hold on him, if the probation officer puts a hold on him, it doesn't matter whether you grant him a bond or not. But if the probation officer doesn't put a hold on him, that means that they're going to be okay with him going back into the rehab facility. So I guess my point is you have other safeguards.
Sure, Mr. George, go ahead.
Thanks, Judge. The booking sheet from the jail shows a hold from Seminole County Sheriff's Office. I think that might be the original warrant that Officer Bentley noted in his investigation. It appears, based on the GCIC, that's probably a probation warrant. So it looks like the defendant already has a probation hold.
Yeah, at this point, Mr. Lewis, I'm gonna deny bond, but I'll state it for the record with leave to renew your bond motion so long as the case is not accepted in Superior Court,
Okay.
and I lose jurisdiction over it. If you can establish that, I just don't want to leave it open-ended because I have to believe Mr. George makes a good point. It's the fact that he was actually, the hold that the officer saw would have been a probation, unless there's more to the criminal history that's not even on GCIC and CIC, which stranger things have happened. But the fact that we're trying to piece together Mr. Wampler's criminal history causes me concern as well, and genuinely concerned for his safety as well. I did just find over another meth case and he was in rehab. So that makes me concerned for you as well, Mr. Wampler. I think your choices are putting yourself in danger right now, not only from a custodial perspective, but from just a human perspective. So I'll deny bond.
You have a question? One second, you have a question? Okay.
Actually, I would like to see if I could explain the events while I was arrested. So I gave consent to search my car.
Oh wait, here, don't, Mr. Wampler. There might be a process to file a motion to challenge the arrest and the evidence procured during that arrest, but this isn't that place. I can only determine on probable cause. So Mr. Lewis is an extremely skilled attorney, and you can talk to him about filing any appropriate motions to exclude any evidence. I just can't, it's not that I don't want to or don't care, I just can't, because that's not the proceeding today. So I'm gonna bind it over, but again, Mr. Wampler, I think that hold is probably sufficiently in place that we would otherwise have to deal with Seminole County anyway. So I'm not comfortable on bond. I think your criminal history is such that you're not a good candidate for bond, especially given what I've found over. But Mr. Lewis, if you did want to file a bond motion subject to not being indicted or the Superior Court not assuming any responsibility, that would be considered in the appropriate and necessary course.
That's fine. Thank you, Judge.
All right, here's what I'm going to do. Mr. Lewis, if you wanted to, did you want him to hold Mr. Wampler so you could talk to him?
No, I will talk to him upstairs, Judge. That's fine.
Okay, I'm going to admit then that concludes I'm going to stop the recording for this so I can just send a separate link.